testify here today. Indeed, I'm honored to be here. Let me begin, though, by noting briefly that I'm appearing here on my own account and do not represent the views of my law firm, its clients, or any other entity or organization which I'm affiliated, and I'm also not expressing a view as to how you should discharge ultimately your advice and consent function. Without a doubt, Justice Sotomayor is both an accomplished jurist and an experienced lawyer. It is nevertheless critical that the Senate weigh her understanding of the judiciary's proper role in our constitutional system before consenting to her appointment. In my view, it is particularly essential that the Senate probe her views on the proper judicial handling of national security cases. This is the case for two reasons. First, the United States remains engaged in a protracted global war against Al-Qaeda and Taliban. Winning this war is essential to our country, and its conduct has presented novel legal challenges rarely seen in previous conflicts. Second, despite Judge Sotomayor's long and distinguished service on the federal bench, she has not had an occasion to consider many cases in the national security area. Therefore, the central topic of a committee's inquiry should be Judge Sotomayor's understanding of the proper role of Article III courts vis-a-vis the executive and legislative branches area of national defense. To the extent these hearings, in your judgment, have not produced sufficient information regarding her views in this area, I would urge the committee to pose written questions to her. As you know, Congress and the President have traditionally been accorded near plenary authority in the national defense and foreign policy arenas, particularly when the conduct of armed conflict is involved. In recent years, however, the Supreme Court has dramatically expanded its role in these areas. In my view, it has significant and negative implications for our government's ability to prevent another devastating attack in the United States and be able to win this war. Indeed, there can be little doubt that the principle that the Supreme Court has developed since Hamdi versus Rumsfeld was decided to, in 2004, make it more difficult for the United States to defeat any enemy that resorts to unconventional warfare. For example, the Supreme Court has imposed what is proven to be an unworkable habeas corpus regime with regard to detainees now held in Guantanamo Bay, Cuba. Meanwhile, the lower courts have begun the process of extending this habeas regime to individuals captured and held in the United States and other parts of the world, particularly at the Bagram Air Force Base in Afghanistan. This development, in my view, threatens our ability to wage war in the Afghan theater in general and presents problems to operations of our special forces in particular. I want to emphasize that this judicial activism was not prompted by or was exclusively directed at the previous administration's alleged exaggerated view of executive power. To begin with, the Bush administration's use of presidential powers, in my view, was far more modest than that of a previous wartime American president.